And so
don't we have a number of Supreme Court cases that allow for spending clause statutes to bind non-recipients?
Your Honor, I believe the only example you saw in the yellow brief was the Franklin case, where my friend said that the 11th Circuit had a pre-existing case on the books that controlled the answer.
What about Grove City?
Your Honor, I don't recall the history behind Grove City, but I guess what I tell you is that this is an extraordinarily unique context where you have federal courts of appeals on-point precedents both before and after RLUIPA's enactment that are like unanimously telling any state operating within the regional borders of those circuits, like this is just not a thing, and that's why.
So are you distinguishing Salinas, Sabri, and Dole? I mean, they were binding non-recipients, right?
Your Honor, I want to resist the characterization of them as non-recipients because I think you talk about recipients and non-recipients when you're talking about spending clause legislation. 666, all of those cases, that's not spending clause legislation. That's what this court said expressly at page 608 in Sabri. And so once you conceive of a statute like RLUIPA as spending clause legislation or not spending clause legislation, that's going to dictate which path, petitioner's given you, which path you choose. And that's what I'm saying.
Assuming that spending clause legislation matters. This is going back to the point with Justice Kagan. Assuming that it makes a difference that it's spending clause legislation, you say, then we can distinguish all these other cases.
I think it has to matter, Justice Jackson.
Even though we said it didn't in Tlefsky.
Your Honor, this is the only reason we're here today is because Congress used its spending clause authority to pass RLUIPA. If it had never done that, we wouldn't be here today. And I think petitioner has the burden to tell the court either you use spending clause authority or you use the 666 path.
Spending clause legislation, it matters because that imposes a bar of clarity that usually is not imposed. So when we read the statute, we have to be cognizant of the fact that it was passed pursuant to the spending clause, and we have to say, is this clear enough?
Right.
But that doesn't have anything to do with the questions that you're now talking about, because once we get to this constitutional issue, we've already decided the statute is clear enough, and the question is only, could Congress do this?
So I respectfully disagree with that, Justice Kagan, for this reason, which is Cummings reiterated that Congress only acts legitimately when it sends federal funds out and it gets a reciprocal promise to comply with conditions in return. Sure, you can say that that existed here as to the state, but you cannot say it with respect to the state official in his personal capacity. One, because he never received—
Yeah, but that's what I'm saying. That's always true with respect to 1983 suits, is that you can always say, oh, the state understood this, but the state employees did not. Now, in fact, that's not true as a factual matter. State employees are well aware that 1983 suits exist and that other federal remedies exist too. But the point that I'm making is that this RLUIPA is no different with respect to putting an employee on notice than a 1983 action is.
And, Your Honor, I think if and when this court gets a Section 1983 action where the underlying substantive
We can strike that down too.
No, well, I think you're going to have a question, Justice Kagan, about whether Congress could use its spending clause authority to create the substantive right that runs against an individual person in his individual capacity. That's not a question the court has answered. I would say, if you eventually have to answer it, I think the answer is no, because that just is completely contrary to how this court has conceived of the spending clause and the contract analogy that undergirds it.